order the meeting of the Independent Ethics Review Board on Monday, December 4th, 2023 at 5 p.m. I will now call roll. Please respond and advise whether you're attending in person or remotely. I believe we are now all in person. Mr. Andrew Wolf.
Here.
Ann Malika.
Here.
Chris Crosby.
Here.
Raquel Roberts.
Here.
Stephen Traley. Oops. Mr. Doug Earl.
Present.
And Larry LeBeau.
Here.
Okay, and I, Krista Stegmiller, chair and present in person. Additionally, we have Mr. Timothy Kerwin from the Kerwin Law Firm here to assist us today if we have any legal questions related to today's meeting.
Thank you. Good evening.
Do we have anyone signed up for public comment? Okay. Item 3, consideration of an action on the minutes of the October 11th, 2023 meeting. Are there any changes, edits, additions to the minutes? If there are no changes, may I have a motion to approve? May I have a second? All in favor? Aye. Minutes approved. Oh, any opposed? Okay. Item 4 is the review of an action on the ethical complaint in accordance with the section 2-99 of the City of Sugar Land Code of Ethical Conduct. The complaint is alleging a violation of the Code of Ethical Conduct by Mayor Joe Zimmerman. And in accordance with section 2-99 of the Code of Conduct, our review today is limited to determining if sufficient cause exists to proceed with an investigation or if the complaint should be dismissed. We will not be discussing the merits of the complaint, and we will not be receiving any testimony related to the complaint itself. Our review is strictly limited to the city attorney's report regarding the complaint and compliance with section 2-98, section B2. So our options, I will review Meredith's, the city attorney's report, but prior to, I just want to remind everyone that the options for an outcome are dismissed as frivolous, number 1. Number 2, dismissed because the subject conduct was undertaken in good faith reliance on a formal written opinion by the city attorney or investigated. I will now review the report provided by the city attorney. Number 1, the complaint must meet the criteria set forth within the Code of Ethical Conduct. And the first criteria is whether the allegations were made timely. The complaint was filed on November 7th, 2023, and relates to the conduct that allegedly occurred on May 11th, 2023. Section 2-96 requires that a complaint be filed within 1 year of the date of the violation is alleged to have occurred. She concludes that the complaint was in fact filed timely. The second item, criteria that must be met, whether the allegations are made against a person regulated under the code. Section 2-76 states that the code applies to all officials. She concludes that the allegations are made against a person regulated under the code. Item 3, whether the allegations, if true, might reasonably constitute a violation of the code. The complaint alleges a violation of section 2-103. 2-103 is a penalty for filing false complaint or giving false testimony. We all have our own copies of the Code of Ethical Conduct. I can read the section, or if you've reviewed it, we can move forward to the next criteria. Okay. So item 4. Oh, and the conclusion was that a reasonable person might determine that these statements are in fact a violation of the code. Item 4, whether the request for hearing was signed and sworn by the person making the allegation. The complaint appears to have been signed by Diana Miller and sworn to before a notary public. She concludes that this requirement is also met. Item 5, whether the city attorney has issued a written opinion relating to the allegation. There is no written opinion relating to this allegation, so we move forward with the next item, and it's whether the city attorney recommends the IERB, our board, dismiss the allegations or conduct further proceedings. She concludes that the complaint meets the filing requirements of section 2-97 of the code, and therefore recommend that the complaint should be forwarded to our board for review and decision on whether or not to dismiss or investigate. So I will open it up to the board for discussion. Has everyone had a chance to review the complaint? And do we have any initial questions or comments around the complaint? Again, we are not discussing the merit of the complaint, but the complaint received itself and whether it meets the criteria, and does the board feel it should move forward with an investigation?
Both reviewing the complaint here and electronically, I can't read any of the screenshots or the evidence, so I don't know that I can adjudicate anything that I can't read.
Does anyone share Mr. Wolf's opinion or comment?
I agree, and this is more of a technical question. So is there a need to submit evidence of the mayor's testimony, like minutes or recordings? The documentation that was submitted was indirect, meaning there were snapshots of text messages and slides from the individual who the complaint was filed against. Because it was indirect, is there something to say about that, or should we receive more direct evidence of the mayor and his commentary, his testimony? So I don't know if that's a legal question, but it's
somewhat
more of a
legal question,
technicality.
so I will jump in. The purpose of this meeting is very limited. It is, do you have a threshold to move forward with an investigation? So if you cannot read the complaint, and I'll tell you, I could not read it either. I did reach out to the city attorney specifically and asked her, hey, can I get a better copy of this? I cannot read it. And she said, this is the copy we have. And so there's no better copy out there. I want you to be aware of that. I did double check that to make sure that maybe it wasn't something on my computer, or was I pulling it up on my phone or something. There is no better copy out there that they were provided by the complainant, Ms. Miller. Okay. So your threshold question is, number one, does this board move forward with an investigation? Okay. Taking Mr. Wolf's comment, if you all can't read it, that's somewhat of a threshold problem. I suspect, and do not know for sure, I suspect if you dismiss the complaint based on not being able to read it, that would be a valid option this board has. How do you move forward on a complaint that you cannot read the underlying substance of that complaint? I suspect if you do that, the complaint may be refiled, and we'll be sitting back up here again in a few weeks I'll have a different suit on at the time, but we'll be right back up here, okay? If you decide to move forward, knowing you cannot read it, as part of your investigation, you could ask for clear copies of whatever this is. I don't know if some of these look like indirect evidence, maybe a text message, and what you will need to be focusing on is what was said under oath at a prior meeting. And I don't know what this is. Does that help answer your question a little bit?
It helps, certainly. I just didn't know if, just on the grounds, let's say if it was readable, is it sufficient to receive indirect communication, the text messages, the references to slides, versus something more direct, like a recording of the mayor's testimony?
I think that the answer to that is we're not there yet. That would be your future. If you could read it, you would be able to say, let's move forward, because I see there's some direct evidence here, but you don't even have that at this point. But again, this board could still move forward and ask for that, almost knowing kind of procedurally where we're going to maybe wind up, but that's this board's call. No, we have our full.
So he's a member.
He-
This board?
Yes,
Oh.
the two alternates were seated.
board seated? No, sir, I'm sorry.
So I was gonna add, yes, I agree, you can't read what is on these slides, but you can see and quotate, to me, it's like they're quoting what's being said. So I guess when I was reading this, I kept thinking, well, I have some questions, I have some questions, I have some questions. And the investigation, if that's determined, could quickly answer those questions. But I don't have the, I felt like I had questions reading this, in addition to not being able to read those slides, but all the quoting that was allegedly said.
And I'm gonna make a statement to be repetitious. So I mean, with the information that we have, we can either dismiss it as frivolous, dismiss it because the subject was taken under good faith reliance on a formal written opinion. That doesn't exist. So option 2 is stricken. So it's just to determine whether or not it warrants an investigation based on what we've received. If your stance is we haven't received information to warrant an investigation because it's illegible, then that's certainly a stance and opinion that you could take. What I hear from Mr. Kerwin is that, should we go down that path, we might be revisiting this with the information that we need to make a more informed decision. Conversely, on the flip side of that, that would be something if we do, select to investigate, that we would request that information, obviously, so that we had factual information that's legible, that we could make an informed opinion. So I guess that's really the two sides of the board that are here to discuss, because it meets all of the other criteria.
So.
And
okay.
I'm sorry, go ahead.
No,
You sure? So the reason I kind of harp on this question is if we are going to ask for clarity, like documents that are legible, do we need to be asking that? Would that be the feedback, or do we then ask, could you provide the recording as opposed to the documents? Like if we're trying to give this person another chance to provide information that will help us make an informed decision, if there's a way of presenting that is technically inadequate, being that it's indirect, then we're kind of circular. I'm just trying to avoid us having to do the circular dance.
I hear what you're saying. So you're saying even if we request the information, it may not still be sufficient to have an informed opinion. Is that what?
If
I'm hearing you
it's
say?
technically not sufficient evidence, well, I guess we will decide if it's sufficient evidence. I'm just saying if there's a technical legal limitation where indirect is just not acceptable, not judged by the ethics board, but just in general, is that acceptable? And if it is, then fine. We'll just ask for that. But if it isn't, I'd rather us ask for what is legitimate as far as the legality of it, not whether or not it's sufficient evidence. I don't know if
Mr.
that
Wolf,
makes
you have-
sense.
If we do any type of dismissal, so if we choose to investigate, that does trigger a timeline of events that will follow. And those could be extensive, because if we're going to ask for the records of somebody's phone, that could take substantially longer than our time frame for investigation. If we dismiss and that doesn't preclude both sides from gathering more stuff to show us, and we come back and we look at everything again, And then say, great, now that we can read it, I know what I'm talking about, I know what you're talking about. We can choose to investigate it. But based on what I have been given, I don't see anything that says there's anything to investigate, because you haven't shown me what it is you're saying they did, or he did.
A question for Timothy Kerwin. So we have three choices. I mean, the guidelines say we have to have three choices and one's taken away. We have a lot of questions, you know, so it's like, I haven't heard anyone say this is truly, like, I don't know if there's evidence that this is frivolous though, because it's blurry, you know, we don't know. I just feel like if it's frivolous and it's not, we don't really have any, it's frivolous or we investigate. Those aren't, we kind of are forced to make those choices. And I think if we have questions, isn't that an investigation? We're asking, I mean, we're kind of implying we have questions. So it's not frivolous. We have questions. So we'll have to investigate. That's like a legal question.
I think based on, this is sort of, I would say, somewhat of a unique situation in the sense that you have a complaint in front of you that I think every member on this commission has said is illegible. And so you could dismiss this, say it is frivolous because it is illegible. You're not making the word frivolous as the underlying merits of the claim. You're saying it is frivolous because it is illegible to every member, plus the attorney, plus the city attorney. And so that is something you could certainly do. Or the other option, you only really have two, is you could investigate and ask for a legible copy, plus what the commissioner said down there was, we want whatever evidence, direct evidence that you would want to hear based on what you might think these are in this packet. I want to kind of go back and answer your question as well a little bit.
Because, yeah, I guess that definition of what frivolous is, and now thank you for that clarity. So be not able to read it would be frivolous. Okay.
I think you could make that. I think that would be a logical argument that this board could absolutely make.
Okay, thank you.
And I think both parties in this have a right to be heard. And us going forward and not giving them that opportunity, I don't think is fair to either of them. Because then there's an investigation against a person who we have no idea what they're being accused of. And then there's somebody who thinks that the mayor did something wrong. And their concerns are being ignored. I'd really love to be able to see what they have to say.
So
But based on what it is now, I would make a motion.
Are you making a motion?
but before you
Okay,
make your
sorry.
motion, I want to hear your motion, but before you do, I would really love to give Doug, Larry,
Okay.
and Chris an opportunity if there are comments before we go down that path. I want to make sure that everyone's heard on the board. And if there are other feedback or thoughts, not to put you on the spot, I want to provide that opportunity.
You're putting us on the spot.
No.
I agree that it's a struggle to understand what exactly is being said here, because we start out with several things that really do not even relate to Mayor Zimmerman. And then, which is the force or the base of the complaint. But then we secondly have information that says this, and this, but there's nothing to actually document what exactly, because we can't read it. And so in my mind, there's nothing here substantive to say this is worth investigating because we can't understand it. That's my take.
Thank you.
Personally, I just think it is frivolous, period, because you can't read it. And going forward, it's just frivolous, period.
My opinion is oh gosh, sorry. To vote to investigate would be legitimizing the non-evidence. And so I lean in the other direction. Although honestly, I would like to be able to read something, to be honest, you know, in all honesty, so that you know, it's hard to vote on something that is unclear.
Yeah.
And that's what we're being asked to do.
So if it's decided that it's frivolous at this point, they could come back and make it more clear.
That's correct. They
So-
can refile the complaint as long as they're within the time frame that your ordinance provides, which I believe is 1 year.
Yes, and it was from the May
From
hearing,
the May
so
hearing. So they have
there's
time.
plenty
to-
of time.
If you were, we would, in fact, if you look at, deciding whether it's frivolous, there's some threshold questions, and I don't even think you can get to some of those questions
Mhm.
on the frivolous part because it is illegible. So, one of them is the nature and type of any publicity surrounding the filing of the complaint. And so it goes on to the list like 4 items. I'm not sure you could even reach some of those because of the fact that the underlying complaint is not able to be read.
I think, Doug, you make a really strong point in the sense of setting precedents too, right? So we want to make sure we do our due process, we follow the steps, but we want to also make sure that the right things are in place before opening a formal investigation. So I think that's an additional point that you've made.
And to add to that, just thinking on the last hearing, I felt as though we came to the conclusion that maybe even on the front end, we should not have requested further investigation because we didn't really have sufficient evidence. The mayor just didn't, there were some gaps in what the mayor submitted as the complainant. So I'm for, at this point, dismissing it due to it being frivolous. And then if they do come back with more information, sufficient information where, we could then decide it warrants further investigation, we could do that, but really just be careful in how we make that decision because there still could be some gaps and some curiosities, but just because there's gaps and curiosities, that doesn't necessarily warrant an investigation, right?
I don't want there to be a mayor or any person in this town who's running it that's doing something wrong or did something wrong. But I also don't want to taint somebody's name with something that it's the equivalent of a cop saying to the judge, well, they did something wrong. Like, what did they do wrong? Tell me what they did wrong, and I would gladly investigate it. But at this point, there's nothing that I can see based on what was submitted that makes me think we go farther.
So I interrupted your motion earlier, but if anyone has a motion,
And if you do have a motion and based on what I've heard, if your motion is to dismiss based on it being frivolous, if you could say for the record that this is the case, I'm not putting words in your mouth, but if it's frivolous based on the fact that it is an illegible complaint, that would be helpful to put that in the motion because we will have to inform the complainant of that.
Anyone else got anything? Well, at this point, I would make a motion that based on a lack of usable evidence, that we dismiss this as frivolous. And if it comes back up again, hope that we get
do we have a second?
used.
All in favor to dismiss the complaint as frivolous on the basis of illegibility of the information provided? All in favor?
Aye.
Aye. Any opposed? The complaint is dismissed as frivolous. Motion carries. That concludes the agenda for today's meeting. Do I have a motion to adjourn? All in favor?
Aye.
Aye. Meeting adjourned.